law.MIT.edu, the computational law research unit at MIT, and I run civics.com, a legal tech consultancy. My background is as in-house counsel and as a, I guess I'd say as an avid technologist. Thank you.
Terrific. Michele?
Hi, folks. Good to see everyone. My name is Michele Lee, and I'm Deputy General Counsel at Pinterest, where I work with a number of fantastic teams analyzing interesting online platform issues, just like this one. And prior to that, I was a senior director at Twitter, where I was responsible for global litigation, regulatory and competition issues. I've spent a long time involved in tech issues, and I'm excited to be talking about this topic here today.
Terrific. We have a lot to talk about. Obviously, ChatGPT, Midjourney, Copilot, and other applications have really changed the landscape in Hollywood and digital Hollywood in the past, really just 6 months or so. And in the copyright area, we're dealing with a number of issues. First of all, the liability for inputs or potential liability for training algorithms that are used for machine learning and generative AI, and the outputs, the potential exposure for what is created. We know from the monkey selfie case that AI itself cannot the output of AI itself cannot be entitled to copyright protection. But with respect to the uses, there have been some lawsuits filed, and companies actually for years have been grappling with this issue. I'm a litigator, and many of the issues that are raised by copyright and generative AI are the kind of issues that we've been litigating going back really even to the 1990s with the early cases involving screen scraping and database protection. And the question is, to what extent can you use third-party works to train your algorithms? And of course, if you don't have complete sets, you've got a real problem because you're training algorithms to do things without complete source of information. But the question is, to what extent can you use it, and to what extent, may it be potentially fair use? And then also the outputs. If something looks awfully similar under current copyright law, which looks just to access and substantial similarity, there are real potential infringement issues. So let's jump into this right now. And before we even get into the legal issues, Dazza, could you outline the technology so that everyone watching this presentation and participating is on the same page in terms of what we're talking about?
Yeah, I'd be happy to. So, first of all, just to hopefully make this a little bit more relatable, I think everybody by now must have heard of ChatGPT. This is it's the service that kind of hit the road with a bang at the end of last year. And if you haven't heard of it, imagine this. It's a screen with a chat box. You input information into a window, click submit, and what comes back is magic. That's fundamentally how this technology works. And when I say that, what I mean is what comes back is not something that has been the result of computer programs of the type that you would have been familiar with before, which is known as deterministic, based on the application of rules that have a certain kind of result with a given input. Rather, it's almost completely probabilistic. There is a distribution of possible answers that could come out for any given input, and so therefore we are frequently surprised by what the technology can do. The performance level, when I say magic, I'm being a little cheeky, but in fact, the performance level is something that I would say is akin to what one would expect from a human. If you had asked a human the same input, say with a question or an instruction, it's hard to know exactly what a person would say. And the quality is roughly on par. There's two. So the core technology behind this, neural networks for large language models and generative adversarial networks, is a kind of machine learning, which is a branch of artificial intelligence. And I think it's notable to say that part of the reason why the quality of the outputs are so astonishing as of recently is there's been a couple of big improvements. One of them is known as reinforcement learning with human feedback, and this is an innovation that is very new. And by it, during the training, during the input that you were talking about, Ian, human beings will basically nudge the model, the large language model, with their judgment about whether a given type of answer is more or less useful, more or less beneficial. And so there's a lot of little judgments that go into the training of the data set and the training of the model. The other one, which I think is, I mean, there's a lot of innovations, but the one that's really got my attention is called Instruct GPT, which is another capability so that instead of this technology just doing what's known as completion, which is what it always used to do when you kind of start, if you were in that input box starting to write a sentence like, today I decided to sue a counterparty because, then it would sort of, and then if you hit submit, it would just continue. It would continue on from that point with the rest of a sentence, because they breached a contract, or because they assaulted my dog or something. So they would just complete. That's still pretty cool, but with Instruct GPT, you can actually give it an instruction. So you can change the input to something like, write me an essay about a monkey and a peanut butter jar or something, and then hit submit, and it will then kind of be able to recognize the instruction and then to output something of the nature of what it's been instructed to do. These, among other innovations, have made it possible to interact with the technology in a very human-like way, and this has been huge. I guess the only other thing I'd like to say about the technology, which I think is particularly notable for us in the legal field, is although the purpose of the panel is to look at legal implications of the technology, I think it's just very, very interesting that the technology is itself an astonishingly good fit for what we do, because the law itself is a kind of a language model. You could say it's very language intensive field. It's being used to augment legal practice all the time, and there's good ways to do that. There's dangers with doing it as well. And so this last thing I want to say, in the context of law, hopefully we can then use to extrapolate to the issues of the day with how use of the technology interplays with copyright law. We can also reason from these things to other areas of law as well. And that is, when using it to practice law, beware that it has limits and it has flaws. One of them is that these outputs are prone to be dead wrong, like factually incorrect. So I'm a big fan of the technology. I think it's great, but it can hallucinate or fabricate, some say. There's biases that have leaked into the training set. And among other things, it could potentially provide information that has legal liability attached to it of various types. And I think we're about to learn a lot about one of those types right now.
Before we move on, I would also emphasize your last point. I attempted to use ChatGPT while I was researching the background of the recent fair use decision in the Warhol case. And I received outputs from ChatGPT that were completely the opposite of what certain holdings were at varying levels of the procedural history of the case. So I just put a warning out to legal practitioners. to do your own research and don't trust ChatGPT wholly.
Yeah, indeed, there's a lawyer who was just recently sanctioned in New York for writing a brief that was extremely well written, but it cited a number of cases that were completely fictional and didn't exist. So good point. So let's talk about these legal issues, because there are a number of liability questions, including liability for the inputs. In order to train algorithms for machine learning and generative AI, you need the universe of information, and much of the universe of information is copyrighted. Michele, do you want to kick off this topic?
Sure, thanks, Ian. It's absolutely no surprise that many generative models, generative AI model tools are trained on data that's going to include protected works. So this is a wide range of, books, images to text. I mean, these days there's sort of tons of websites where folks still continue to go and just find textbooks or novels, and immediately just by Googling, you can find this. And all of this information on the internet has been scraped up to populate these models, which we can call foundation models. So these are the ones where you can use them for many different purposes, but as a baseline. So for example, OpenAI's GPT, they've just sort of swept the internet, sucked in a ton of information, and now use these to train their models to output the information that Dazza described for us. So a lot of websites right now are very much well aware that generative AI products scrape their data or engaged in some form of data access that exceeded what they were originally expecting. And so there are a ton of legal questions that stem from this use of online material as training materials for the foundation models. Some of the ones that immediately have come to mind, and of course the case law on all of this is very early, is breach of contract, where folks say, I gave you a terms of service, I allowed you on my website, and now you appear to have breached that by just scraping my entire website for use in your models without authorization. There are also questions about whether these could be considered Computer Fraud and Abuse Act violations. And there's also, questions about copyright management information and whether that's appropriately being collected. So for the first one, on the terms of service, a website thinking, what do I do now? My website's been scraped. What might I do? And we are already seeing this in some of the lawsuits that have been filed, as well as sort of the bluster around a number of threatened lawsuits where folks are pretty outraged about this. And so websites have argued, there was this terms of service violation. I would consider this to be a breach of contract. Lucky for us, we've already seen a number of cases relating to scraping, and websites have previously all filed. A number of websites have filed lawsuits relating to scraping. In 2019, there was a really interesting case. A company named Genius had accused Google of scraping the lyrics on its website and then republishing them at the top of Google's search results page. So instead of directing traffic to Genius, ultimately their content had been sort of brought into Google, and Google would just show a preview of the lyrics on its website. So originally Genius as a tool had used crowdsourcing. So it used crowdsourcing to maintain its database of lyrics. And interestingly, they thought maybe that someone might be scraping their content. So they snuck in a text watermark, and it's spelled out red-handed in Morse code, which is amazing. And this showed up in related Google searches without any link or attribution to Genius. So Genius, seeing that they had in fact caught someone red-handed, sued Google and claimed that the taking of the lyrics violated their website's terms of service, was considered unfair competition. And they said, you've stolen our traffic, you've caused us to lose millions of dollars. And so this case made its way up through the Second Circuit. And then interestingly, Genius didn't own the copyright to the music. Google certainly didn't own the copyright to the music. But the Second Circuit found that any allegation that Google had breached the terms of service of Genius's website were preempted by federal copyright law. And so ultimately, federal copyright law has a preemption clause, and it bars lawsuits based on state law that's equivalent to any of the exclusive rights within the general scope of copyright. And the breach of contract claims were based on state law. And so this went all the way up to the Supreme Court. Supreme Court said, yeah, we're not going to review us. We're going to let the Second Circuit decision stand. And then interestingly, the Solicitor General, in asking the Supreme Court to not weigh in, said, well, there's also this open question about whether just visiting a website and its terms of service could be considered enough of a binding contract. So right there, in this case, it's a great example of how there are weaknesses with using sort of a terms of service breach of contract argument. Another argument that website owners or content creators might use for the scraping content is an old standby, the Computer Fraud and Abuse Act violations. However, these days, there have been a number of cases at this point, with one of the more famous ones in the tech space, the HiQ versus LinkedIn case. And pretty much at this point, we're at a place where if public websites have not tried to do any sort of access control or limitations on who can scrape the content, and it's just available for public scraping, it's going to be really hard and tough based on existing case law for that to be considered a Computer Fraud and Abuse Act violation. And then finally, one that we've seen already in early litigation about generative AI, website creators might turn towards concerns about copyright management information. So under copyright law, there's a prohibition on removing or altering copyright management information. This is the title, the author, the copyright owner, and other sort of identifying information. And copyright law will prohibit individuals from removing the copyright management information and distributing copies of works while knowing that the copyright management information has been removed and altered, and knowing that this might, induce copyright infringement. So there's a case right now, Doe versus GitHub, and this is one of the first early cases looking at the question of what it means to scrape data. So there are a whole bunch of coders. They sued GitHub, OpenAI, Microsoft, and other affiliates for violating open source software licenses. So they said, we did a lot of coding. We put this coding up in GitHub just like any other sort of, coder might do. And OpenAI simply scraped all this code without authorization and used it so that they could train their own models to generate additional code. So the case is still in the early stages, but at the motion to dismiss stage, which was very interesting, the plaintiffs, obviously at the motion to dismiss phase, we have to assume that plaintiffs' allegations of fact are true. And the allegation was simply that, OpenAI had developed its models using all of this source material of code and then failed to reproduce the CMI, the copyright management information. The court ultimately heard this argument and said, well, it seems like they didn't copyright this. They didn't copy and retain the CMI information. It wasn't simply that they willfully discarded it or got rid of it. They just simply didn't. They had a passive non-inclusion of CMI. And the court said, we're going to let this case go to the next phase. We're going to let it go to discovery. We're going to let this go to summary judgment. So right now, that piece, that sort of very technical piece, it's interesting, that does seem like a credible threat to generative AI. And that risk of scraping content without preserving CMI could pose a viable legal threat. But it'll be really interesting to see from a technical perspective whether sort of, OpenAI and other of these large providers will simply change their models and simply build their models in a way to more actively retain this copyright management information.
Yeah, great points, Michele. And in addition to the input issues, there are of course output issues. Copyright is strict liability statute, so if something is copied when it's inputted, that is potentially copyright infringement. And if it is, the question, of course, is it fair use? Is it there's lots of case law suggesting that technical uses may be fair use, but there are a lot of open questions. And Zach, do you want to tee up that issue?
I'd love to, Ian. Thank you. I'd like to just level set with an example of the technology so our viewers understand what we're talking about. Midjourney is a generative artificial intelligence program that generates images from prompts. So if you can imagine, image outputs have the nature of existing copyrighted works. So the potential for copyright infringement is absolutely part of the equation for these services. Just to remind our viewers, copyright provides the owner of copyright with a number of exclusive rights, including a reproduction right. So obviously, when an AI service produces image-based outputs, for an example, there's the potential to reproduce a copyrighted work. So can the outputs of generative AI infringe copyright? Absolutely, potentially they can, based on infringement of the reproduction right. How would a copyright plaintiff go about attacking this problem? Well, first off, they have to own a valid copyright. And supposing that valid copyright exists, then analysis has to happen about, was there actual copying? And this may be proved by a defendant's access to a copyrighted work. And how do you prove that? One way you might prove it is to have evidence that the underlying copyrighted work was part of a training data set for the generative AI service, which may or may not be difficult to prove. And then you also have to prove that there is substantial similarity to the underlying copyrighted work. Different circuits handle this analysis in different ways, but generally there's an analysis of a total concept and feel, overall look and feel, or how would an ordinary reasonable person fail to differentiate between the two works. Arguments on this matter. OpenAI has said that any substantial similarity in outputs would be extremely low probability and random, and that outputs of generative AI do not generate unaltered data from the underlying training materials. Whereas Getty Images has argued on the opposite side that the outputs of Stable Diffusion are often near copies or close derivatives of individual copyrighted photographs. Other arguments you might hear are that all outputs of generative AI services are potentially infringing because all outputs are based on the copies of millions or even billions of copyrighted works. A few other notes that I think are important for us to consider. If a generative AI service allows outputs of well-known fictional characters, which themselves may be copyrighted, expect copyright liability issues to follow. Another note of importance is that mimicking the style of artistic works is exquisitely possible via generative AI. Copyright law doesn't currently protect style itself, but the ability for generative AI to mimic style in a way that is very degrading to the prospects of the original artist who owns copyrights. Some are saying that may potentially change copyright law to have to consider at least whether style might be protectable in some fashion, or perhaps whether there's some kind of compulsory licensing regime to protect the ability of generative AI to mimic style in such an exquisite fashion. Another thing we need to consider is who is liable for the outputs that are alleged to be copied or infringing. Clearly, we have a number of different defendants. The user that directs the prompt is potentially a defendant based on how the user would choose to use the outputs of the prompt. There are many ways to attack from a copyright infringement perspective. Clearly, the AI service developer is a target of copyright plaintiffs as well, and they're already the defendant in multiple class actions, including Stability AI, Midjourney, DeviantArt, OpenAI, and now Meta. You may have just recently seen a very high priority lawsuit based from Sarah Silverman, which included Meta in the defendant pool. And then you have to consider, is there direct infringement versus vicarious copyright liability infringement? I think direct liability in some cases will be more difficult. Vicarious liability is potentially a natural claim, which applies to defendants who have the right and ability to supervise infringing activity. and where they receive a direct financial interest in such activities. There are open questions for Congress in this space. Congress may wish to consider whether any of the copyright law questions raised by generative AI programs require any amendments to the Copyright Act or other legislation like the DMCA. Congress may wish to consider legislation clarifying whether AI-generated works are copyrightable. Currently, they're not. Who should be considered the author of such works? And should Congress weigh in on whether training generative AI programs constitute fair use? Those are open and important questions, and I assume that we'll hear different opinions and get an answer as the weeks and months proceed from here. And then I think I should speak a bit about potential fair use issues, copyright fair use issues of generative AI. And just to remind our audience, fair use is a defense against copyright infringement that is provided for in the Copyright Act. It provides four criteria to assess whether a subsequent use of a copyrighted work amounts to a fair use. The most obvious fair use questions in generative AI are whether the reproduction of millions or billions of copyrighted works to train generative AI models amounts to copyright infringement or fair use. The arguments in favor of it being infringement are that reproductions are made, as Michele said, without authorization by copyright owners, and often in contravention of contractual terms that prevent it. And the big one, in my opinion, is that many of the outputs of generative AI services are very degrading to the market for the original underlying copyrighted works. Whereas the counter arguments are fair use is appropriate here because the reproductions themselves are not made expressively. Rather, they are used for training and for a transformative purpose. And the reproductions themselves are never made public by the AI services. These arguments are all being tested. We will start to see decisions in very high-profile cases shortly. And then with respect to fair use in the outputs of generative AI services, I think the four-part test would again apply. We have new case law based on the Warhol decision that just came out of the Supreme Court. Some believe, like the RIAA does, that the Warhol decision drastically kind of cut back the power of transformation as forming the basis for a successful fair use argument. Other parties have different opinions. You can look at the Authors Guild and the Google Books case for potentially a fair use output here, but all these things are fascinating, and they're going to keep copyright attorneys very busy for the near future. And I just think before I end this segment, I would love to do a quick, just a quick exposure to what are the terms of use of generative AI services saying to those that are using the services. I'm going to give you just a few examples. Midjourney makes no representations or warranties with respect to the current law that might apply to you. Please consult your own lawyer if you want more information about the state of current law in your jurisdiction. They further state, if you knowingly infringe someone else's intellectual property, and that costs us money, we're going to come to find you and collect money from you. OpenAI's terms say that OpenAI assigns to you all right, title, and interest into your outputs from OpenAI's generative services. You are responsible for the content, including for ensuring that it does not violate any applicable law or these terms. And furthermore, you will indemnify OpenAI related to your use of the services, your content, or any products or services you develop or offer in connection with the services. And that last part is particularly relevant to my business. where the discussions and the decisions about integrating generative AI into other digital platforms are very pertinent. Clearly, OpenAI would push that liability onto whomever uses their service in any way, including platforms. Back to you, Ian. Thank you.
Yeah, and it's really interesting because what as a litigator, both what Zach and Michele were talking about really underscores, I think, an important point, that the way cases are going to be decided may really depend on the facts, because you can make a very strong fair use argument if you're talking about input. So you copied, or not you, but the generative AI company copied, this book among 100 million books, or this script, or this motion picture, whatever it is. And you can make a good argument that this is intermediate fair use, and that it's serving a transformative technological purpose. You can look at the Google Books decisions from the Second Circuit, and there's strong support for it. On the other hand, if you look at the output and something happens to resemble the copyrighted input, that's going to be a problem. Back in the pre-digital era, there was this saying, I don't know where it even came from, but if you got 100 monkeys together and put them at typewriters, eventually, they'd come up with a Shakespeare play. And, I think you can say the same with an algorithm, which is, even if you train the algorithm to not infringe and to just do things neutrally, and if you train the algorithm, well, if you write the algorithm to do things neutrally, and if you train it with all of the content in the world, so it should have no bias at all, the reality is something may appear that looks very similar. Now, if it's just in the same style of an artwork, for example, style is not entitled to copyright protection. But if it looks awfully similar, the current test for copyright infringement in court is access and substantial similarity. And so if it was inputted and if the output looks the same, that may be a tough argument. And, again, there are a lot of business decisions that can be made here. As with any new technology, companies need to evaluate what is their risk and what level of risk tolerance are they comfortable with. But I think we're very much going to see that the cases turn on their facts. And again, that assumes a situation where the algorithm is written in a very neutral way. Obviously, if the algorithm is written to make works that look like Andy Warhol paintings, that's a different scenario. And similarly, we're talking about cases where we assume the output is intended to be neutral. If you have copied every piece of music available, that's quite different from maybe having 30% of your music come from Taylor Swift, let's say, and so you're biasing the outcome. But assuming neutrality, I think the facts may make a big difference. I don't know, Michele, Zach, if you have a view on that.
I think it's going to be, as we're in such early stages of the development of the law, and the facts are just going to make such a huge difference. And I chuckle when I think about the number of associates who are currently sitting around typing in queries to get output that might look identical to their protected works. Because you've got to think, right? It's interesting as you read these cases, because the creators of generative AI, once they scrape the content, they discard the underlying images. And so to go back in discovery and to figure out, what was used to train the models, I think is going to be incredibly difficult. But as you think about all these poor folks who are going to be typing in queries to find, identical content, you've got to think that depending on how hard they work, that eventually they're going to get some really serious hits. And that's going to lead to some interesting discovery disputes and sort of documentation to get to the point of those infringing images for purposes of litigation.
And I just had a further comment, Ian, based on the question about whether this would be very fact intensive. I think you're exactly right there. And I think based on my review of the Warhol decision, and the potential fair use defenses to come, they're very much dependent on facts and dependent on how a court frames the subsequent use. because there are many ways to frame subsequent use that has a kind of beneficial or detrimental impact on litigation. And you know, that makes it very hard to predict. And I think it will just be very interesting times for many of the lawyers that work in generative AI and copyright matters. We're in for some interesting days ahead, certainly.
I think that's very true. I should mention also, for those of you who are watching, if you are interested, I have put up a link to the chapter from my legal treatise on AI and ML and all the legal issues and case law to date. It's over 200 pages, so if you're really a law nerd, there's a lot to look at, or conversely, if you're having trouble sleeping in these difficult times, print it out and read it at night and you'll sleep like a baby. But anyway, the link is in the chat session. Zach, do you want to talk a little bit more specifically about intermediary liability? Because the reality is, where many companies are going to deal with this issue is their use of these tools.
Yeah, I'd love to, Ian. Thank you. And this issue is very relevant to my work now for TikTok, you know, which is an intermediary in many different cases. To level set, what is intermediary liability? It occurs where governments or private litigants can hold technological intermediaries, such as ISPs, social networks, or websites liable for unlawful or harmful content created by the users of those services. And you kind of have to understand two of the foundational laws in intermediary liability that impact them in the US. First being Section 230 of the Communications Decency Act. And this is not copyright related, but we have to just do a quick discussion. It effectively provides immunity from liability for the content posted by users on technological services. And then the second law that's important here is the Digital Millennium Copyright Act, or the DMCA, which provides a safe harbor from copyright infringement for intermediaries. And what it says specifically is a service provider shall not be liable for infringement of copyright by reason of the storage at the direction of a user of material that resides on the system provided by that service provider. Both of these things are very important for both AI services themselves, I would say, and then companies like TikTok that may or may not integrate AI services into their own digital platforms. And so you're going to see, I think, litigation attacking AI services and those platforms that integrate AI services on intermediary liability. And the question is, do the platforms themselves have these safe harbors and shields from liability based on existing legal frameworks? And I think, you know, there are arguments for and against, particularly in the CDA. You could argue that this is just a further development of the legal structures that we've developed for platforms generally. But I think a big difference from the way that we've analyzed these issues so far are that the AI services themselves are theoretically producing content. And that's not something that happens in the case of, you know, user-generated TikTok content on TikTok that's being posted. It's different where there's an AI service that has some ability to participate in the generation of the content. I think another important detail is, to what extent does the AI service itself or the third party that integrates an AI service have any impact or suggestions or contributions to the prompting that produces the outputs? Because I think in that case, you're starting to get, you're making it easier to have courts hold that you're outside the safe harbors. So these things are intermediary liability is going to be critical. You're going to see the I'd say the free speech and technology lobby arguing strongly in favor of just the application of current intermediary liability frameworks to these services. And you're going to see the copyright and other user safety lobbies arguing the exact opposite. And the question for many of us and lawmakers are going to be, where do we fall on these issues? And I think those are going to be initially driven by the outcomes of massive litigation that we're already seeing now. Back to you, Ian. Thanks.
Michele, do you have any other additional thoughts on intermediary liability?
No, I think I'm as eager as anyone else for that first Section 230 case that comes out on these issues. And whether this can be considered sort of user generated content. I there's a lot of speculation right now, but it's going to be an interesting, probably my guess is like probably 6 months to a year we should see something. So very exciting.
Yeah, I mean, it is interesting. I mean, it really should be treated as user generated for any intermediary, as opposed to anyone that directly creates the content. But of course, with respect to state IP laws, there's a split in the circuits right now about whether the CDA even applies. Copyright is completely outside, and there is a sentiment among some, as we saw in the Biden administration's amicus brief to the Solicitor General recently, that things that are generated algorithmically should be outside the CDA. So interesting. Although, again, even if it's outside the CDA, that would be for the generative AI company, presumably not the intermediary. So certainly more to see. Michele, can you pick up actually on another point that Zach made, where he was talking about we're going to see how laws develop and legislators, and of course one place that is always eager to generate law is the European Union. Could you say a couple of words about the EU approach?
Sure. So similar to their legal development under the Digital Services Act and also under the Digital Markets Act, the EU is very focused on being prescriptive. They're not waiting for bad behavior to happen before thinking about whether it fits existing laws. They are very much at the forefront of thinking what will be problematic, and let's prevent platforms from doing it right now. So the AI Act is really focused on, they're looking at data quality, they're looking at transparency, they're looking at sort of their framework for human rights, and also looking at accountability. So right now there are 3 drafts pending on the AI Act, just sort of based on the way that European law is developed. The drafts roughly look at a classification system. So they're going to look at the level of risk that an AI technology could pose to health and safety of a person's fundamental rights. They're going to categorize these risks and say something's unacceptable, high, limited, or minimal. So things that are minimal would just be like spam filtering, would focus largely on transparency requirements, whereas other things like real-time biometric identification in public spaces, which is a little bit scary, that would be considered something like unacceptable risk. And so if things are on the higher spectrum of risk, they'll either be entirely disallowed, or there will be lots of testing, rigorous documentation, output testing, et cetera. Interestingly, now that we've become much more focused, and the work on this law has been happening for quite some time now, but now as the world is focused on generative AI models like GPT, the law is now focusing on additional transparency requirements for those providers. So requiring that if you are a generative AI provider, that you are going to disclose what content was generated by AI. You're going to design the model in a way that prevents it from generating illegal content, which is very tall order, and also publishing summaries of copyrighted data that's used for training, which should be a very long summary if done in a way that provides any detail or insight whatsoever, because one image could have, be sourced from thousands of copyrighted images all combined together to generate that final output. So we should know what the law will fully look like towards the end of this year. At least folks are predicting that. And then also we're about 2 years before implementation, which is quite some time. But of course, like with any good EU law, there are steep fines for non-compliance. 6% of global income, or up to 30 million euros, which is a lot. So I think a lot of companies are going to be very laser focused on how to comply with the requirements of this law when it's finally baked.
Yeah, it's really quite a lot to look at. We're running very low on time. Dazza, you want to say a quick couple of words about the future, where this is all going?
Yeah, thanks. I'd be happy to. So the main thing I've been thinking through this discussion is that the analysis is appropriately tuned toward basically the first part of the first phase of this new technology, which is what it is we're being exposed to right now. At MIT, where my research lab is, and here in the Bay Area where I live now, I frequently go to, like meetups or walk into people's offices where I can see, like with my eyes, really big things that are in the pipeline that are coming soon to, an internet near you, that could significantly change the legal analysis and the business models and, the nature of the thing. Some things to keep an eye on for the future include, first of all, just how to understand and utilize the existing technology. So APIs that let you integrate systems are doing there's people and whole clusters of companies are being born every day that are finding ingenious ways to use APIs, back to OpenAI and Anthropic and others, to add new capabilities, some of which can be configured and tuned to address some of the legal issues, not to mention to unleash lots of new business value, rather. There's also technology that's not like today. People are experimenting with, how I said earlier, and some people referenced the kind of probabilistic nature of this. There's the more traditional form of AI is symbolic. It's kind of like a syllogism, like a pure logic approach. People are looking at ways to combine symbolic logic and generative AI in very interesting ways that could very much change the outputs. There's also planning models that are big with the military and simulations. People are combining these very different forms of AI in ways that could really change the legal analysis, not to mention the upside. And on the upside, the main thing I see in the future is that there's empires to be built now with this new technology. I mean, we're talking about it, which is appropriate. I don't think almost any of us have yet fully understood the deep total economic and social impacts of these technologies, which I feel confident are profound. McKinsey puts it at over $4 trillion bump to the economy in the short term. I think they are significantly underestimating how this is going to play out in our existing business models and the new ones. And when there's a lot of new value, you know what, that has an impact on how the law is applied, because we're optimizing for multiple interests here, not just the interests of copyright holders or vestiges of the immediate past. And so I think we're going to see some new adaptation of the technology and the way humans adapt to the technology. That's what I foresee is change.
Well, and on that high note, let me thank you, Dazza, Zach, and Michele. This has been a great panel. We could continue talking about these issues for the rest of the week, but thank you for joining us. Enjoy the rest of the Digital Hollywood Conference, and it's been a real pleasure moderating this panel. Thanks.
Thank you.
Thank you.